Welcome to another ABI podcast. This is Bill Rochelle, ABI's editor-at-large. Today we're going to be talking about the new bankruptcy rules, or I should say amended bankruptcy rules, that become effective on December 1. Our expert commentator today is Una O'Boyle, just now elevated to be the clerk of the United States Bankruptcy Court for the District of Delaware. Ms. O'Boyle is a person with a long career in bankruptcy. She began by clerking for bankruptcy judges Tina Brosman and Burton Whitland, who of course are two of the finest judges ever to sit on any bench anywhere. We fast forward a number of years and we find that Ms. O'Boyle is spending 8 years as the chief deputy in the clerk's office in the Southern District of New York. And then, as you guessed, on September 1, she was named to be the clerk of the Bankruptcy Court for the District of Delaware. And so far, Ms. O'Boyle has devoted 23 years of her career to public service in the Bankruptcy Court. I've got to say, however, that I don't think this job in Delaware will be the end of her career by any means, because if you look at New York, you see that the clerk, Cecilia Morris, was elevated to the bankruptcy bench, and she is now the chief bankruptcy judge for the Southern District of New York. And Ms. O'Boyle, I suspect there is going to be something like that in your future, although frankly, I think that your talents might be best spent as the clerk in some very busy, perhaps circuit court, helping them communicate more effectively with the legal community as well as the public to help those courts juice up their websites and their electronic filings, because, Ms. O'Boyle, that's something you have done very well.
Thank you, Bill.
Well, you got to give a plug for people who deserve it, and you're that. And frankly, a court that could use your help more than any is the U.S. Supreme Court, which lags the circuits and the district and the bankruptcy courts in terms of having a good website, but that's beside the point. In any event, let's talk about the rules, Ms. O'Boyle. We've got, as I understand it, I guess it's 4 areas where the Rules Committee proposed new rules that become effective on the 1st of December. We have the so-called Stern rules. We have new rules on the 3-day mailing, and we have security interests in principal residences, and also we have new rules dealing with cross-border bankruptcies. But let's begin with the big one, Ms. O'Boyle. Let's talk about the Stern rules. As I understand it, that has been an off and on history in terms of the proposal of new rules. How did that come about, and what happened?
Well, an amendment to a federal rule usually takes about 3 years. But in 2011, the Advisory Committee on the Bankruptcy Rules began considering whether they needed to be amended in response to the Supreme Court's decision in Stern v. Marshall. At that time, Bankruptcy Rules 7008 and 7012 required parties to adversary proceedings to state in the complaint and any responsive pleading whether the proceeding was core or non-core, and if non-core, whether the pleader consented to entry of final judgment by the bankruptcy judge. After Stern, the proceeding might be designated as core by statute, under 28 U.S.C. 157b2, but be beyond the constitutional authority of the bankruptcy court to hear and determine the matter without the parties' consent. So the committee proposed amendments to both rules to eliminate the distinction between core and non-core, and to require parties in all proceedings to state in their pleadings whether they did or didn't consent to entry of a final judgment or order by the bankruptcy judge. They also proposed amendments to Rule 7016, which is the pretrial procedures, to direct the bankruptcy court to determine its own authority in a proceeding, and to Rule 9033, the proposed findings of fact and conclusions of law, to omit the rule's limitation to non-core proceedings. So the amendments were published for comment in August of 2012. They were given final approval by the Judicial Conference and submitted to the Supreme Court for consideration. Shortly thereafter, the Supreme Court granted cert in Executive Benefits Insurance Agency v. Arkansas, and one of the issues in that case was whether Article 3 permits the bankruptcy court to enter final judgment on a Stern claim if it has the express or implied consent of the parties to do so. So because the proposed Stern amendments relied on the validity of consent, the committee decided that the Supreme Court should not consider them while the issue was pending before it and withdrew the amendments. In June of 2014, the Supreme Court decided our consent, as you know, without reaching the consent issue. But a few weeks later, they granted certain Wellness International Network versus Sharif, which also presented the issue of consent. And so as a result, the amendments remained withdrawn. In the meantime, however, some of the district courts and the bankruptcy courts had amended their own local rules and orders of reference, similar to the proposed, federal amendments, to deal with the Stern dilemma. So in May of 2015, the Supreme Court issued the Wellness decision, holding that the bankruptcy courts may adjudicate Stern claims with the knowing and voluntary consent of the parties. So the proposed amendments were resubmitted to the Supreme Court on an expedited basis in October 29th of 2015 to become effective this December.
So now we have them, huh?
Now we have them, 5 years later.
And what is the principal theory behind these amendments, so we can really get a grasp of what they do without looking at the precise language?
They really just remove the core, non-core distinction and just require the parties to either consent or not consent to the entry of final orders or judgments by the bankruptcy court.
And do you think that in case somebody evades the rule by not indicating whether they consent or not, do you think that is going to go in the direction of implied consent, or how do you think it might come down if it does?
I mean, implied consent has become an issue in some of the cases. I think on a practical matter, I know the judges that I dealt with in New York primarily. If they have a pretrial hearing and they have the pleadings before them and someone has failed to state it, they're going to demand that the parties state whether they consent or do not consent. I think on one of the local rules, it ends with, if no such statement is included, the pleader shall have waived the right to contest the authority of the court to enter final orders or judgments.
Well,
whether that holds up or not, whether that holds up or not, I don't know, but it's in the local rule.
Yeah, well, that gives the judges some real power in their own hands. Let me ask you this, Ms. O'Boyle. When does this rule and the other rules become effective? Are they applicable in pending cases or only in cases filed on and after December the 1st? Well,
the order submitted by the Supreme Court is that they shall govern in all proceedings in bankruptcy cases thereafter commenced, and insofar as just and practicable, all proceedings then pending. So I guess it's open to interpretation.
Yep. Well, I guess since you work from the proposition that rules cannot affect jurisdiction, questions as to whether or not one of these rules is applicable may not have life or death influence on the outcome of cases, but I suppose that's an issue we'll have to confront in the future, perhaps.
I think where it might come up, it maybe is even in the next rule with 3 days if someone's fighting over notice, whether.
Well, that's exactly right, and that's why we ought to do 3 days next. This goes back to the notion that you and I both learned in law school, which is that when you serve a paper by mail, you get 3 extra days for answering. But now, of course, hardly anything is served by mail. It's all electronic. So what did the Supreme Court do in terms of changing the rules?
Well, the Standing Committee and its advisory committees have been working to coordinate rule changes that have been made necessary by technology. So this amendment to 9006F is one of those, the outcomes of that. And it parallels the amendments to Civil Rule 6 and Criminal Rule 45, Appellate Rule 26, removing the reference to service by electronic means. So I think initially when electronic service first came about, or electronic filing, it was not always clear, if computers were compatible, if you could download attachments, and so the 3 days applied to electronic service. But as you say, Bill, fast forward to this day and age, electronic service is much more reliable now, and so it's come to the point where they can delete that 3 days, the 3 days extra that you need for mail. The other thing is, too, the committee was looking at the fact that many of the rules have been changed to ease the task of computing the time frames by, adopting those 7, 14, 21, 28-day periods. And so adding the 3 extra days complicated.
Are there still going to be some circumstances in which you do get 3 days? I mean, is stuff ever really served by mail these days? Or is that just out the window?
There is, they do, the rule does provide that it's 3 days for service by mail, or under Federal Rule 5B 2D, which is leaving with the clerk, or F, other means consented to. So if you consented to other ways. Next year, Federal Rule 5 there's proposals to amend it further to establish a national rule on electronic filing for things like making it mandatory for all parties represented by counsel, and deleting the requirement of consent when service is made on a registered user through the filing system. So they're looking at expanding that even further.
By the way, I think right here we ought to mention, Ms. O'Boyle, that your former boss, Burton Lisland, was the person who literally invented electronic filing and service, right?
Yeah.
Wasn't he the one who moved the Southern District of New York to go electronic?
Oh, yeah. We went electronic with Macy's way back, I guess, in the 90s with a 500 baud modem.
Goodness gracious.
And it was either a Westlaw or a Lexus package. Yeah, but so that was predated the administrative office of the courts, system filing. So.
All right, and I remember well how in the Macy's case, Judge Lisland said that, by goodness, he said, the Macy's Thanksgiving Day parade is going to be held bankruptcy or no bankruptcy.
Yes, he did.
One of the best rulings I think ever made. Let's talk about the cross-border rules. What are those all about, and what are they intended to?
So the cross-border rules are really just to improve procedures for Chapter 15 cases. It was a little confusing. When Chapter 15 was added to the Bankruptcy Code in 2005, replacing Section 304, Rules 1010 and 1011, which govern involuntary cases, were amended just to insert provisions governing cross-border cases. They kind of just stuck into those rules. So the amended rules just remove those Chapter 15 related provisions from the involuntary rules. And in place, Rule 2002 Q1 was amended to clarify the procedures for giving notice in Chapter 15 proceedings. And it also provides for the court to promptly schedule a hearing on the petition for recognition, just in accordance with Section 1517. Then Rule 2002 Q1, and this was an issue that used to come up in Chapter 15 cases. It recognizes that an initial hearing requesting provisional relief, such as an injunction, like a preliminary injunction, may overlap with the merits for the petition for recognition, because once the petition is recognized as the main proceeding, the automatic stay provisions kick in. So it's almost like the same hearing. So in that case, the rule provides that the court can consolidate the hearings and shorten the usual 21-day notice period for the recognition hearing. And then lastly, a new Rule 1012 is added just to govern responses to Chapter 15 petitions and for the filing of corporate ownership statements by entities responding to the petition. So,
well, that sounds like
logic
and good sense. Logic and good sense come to the rules for Chapter 15 cases. Because, Lord of mercy, with the decisions that are coming down from our courts these days, cross-border bankruptcy is a bigger deal, day by day and week by week, that's for sure. Unlike
304, which were mostly filed in New York, Chapter 15 cases really are filed all over the country in a lot of different districts.
They certainly are. And sometimes, as we know these days, filed when there are absolutely no connections with the United States other than a retainer having been given to a bankruptcy lawyer somewhere.
Sure.
Well, that's a different issue, but one of our judges dealt with a case like that. One of your judges, I think, wasn't it? Very very recently, within the last month. Let's go on and not forget about our brothers and sisters who practice consumer law, because I believe there are some changes, were there not, in the rules dealing with proofs of claim by folks who have a security interest or mortgage on somebody's principal residence. What are those new rules all about?
Right. Well, Rule 3002-1 was actually promulgated in 2011, and it was in response to a problem in Chapter 13 cases where a debtor had successfully completed its plan payments, paid all the mortgage arrears and post-petition installment payments that were in the plan, and then discovered later undisclosed and unpaid post-petition charges and fees. So if some, taxes went up or something like payments went up and they hadn't been notified of it. So Rule 3002 requires creditors whose claims are secured by a security interest in the debtor's principal residence to provide the debtor and the trustee, who might be making the payments, notice of any changes in the payment amount or the assessment of any fees or charges during the bankruptcy case no later than 21 days before the new payment amount is due. So it's intended to ensure that the debtors who try to maintain their home mortgage payments while they're in Chapter 13 will have the adequate information they need to do so. The amended Subdivision A of the rule to clarify when it applies. So the reference to 1322B5 of the code was deleted to make clear that the rule applies even if there's no pre-petition arrearage to be cured. So long as the creditor has a claim that's secured by a security interest in the debtor's residence and the plan provides that the contractual payments on the claim will be maintained, then the rule applies. They have to give the 21 days notice. The rule also applies regardless of whether it's the debtor or the trustee who's making the payments, and the rule generally ceases to apply when the stay is lifted on the debtor's residence.
Well, I got to tell you, that's a really important rule, because Chapter 15 cases cannot last longer than 5 years, and if you learn right at the end of your 5-year commitment period that you haven't paid your claim in full, you can be up the creek without a paddle. And interestingly, the 7th Circuit recently was faced with a case like that where it looked like the 5 years had run out, but the good old 7th Circuit went out on a limb and said, no, and really in exceptional circumstance, the plan can run longer than 5 years. This way people won't lose the benefit of a discharge and having paid out a whole lot of money out of their income to pay their prior creditors. So I can see how that is a really important rule to be sure that consumer debtors don't get blindsided.
Yeah. One of the comments, though, that was a couple of comments were submitted about the rule, and this came up in some of the case law, and that was that applying the rule to home equity lines of credit with balances that are constantly changing make it difficult to comply with this 21-day notice requirement. So an issue came up before one court that says, well, there's nothing we can do about it. Another court used 9006 to extend the time, but the Rules Committee decided to go ahead with it anyway, but they have published for comment for next year an amendment relating to the home equity lines of credit, which allows the court to modify the notice provisions.
Yeah. Well, that's the way it always is, isn't it? Where business practices are out ahead of the development of law and rules. But I guess that's something we have to live with. Ms. O'Boyle, I thank you very much for explaining to us what these new rules are. And I think what this means is that people who publish printed versions of the rules are going to make some money, because I guarantee you, everybody ought to go out right now and buy new copies of the rules, because they become effective on the 1st of December. And again, Ms. O'Boyle, I thank you very much for being our guest and our expert on this ABI podcast. Thank you and good day.
Thank you, Bill.